key reason for the younger attorneys in here, and I don't see that many young attorneys here, which is just disappointing, is because if you don't object to something and then you want to later raise it on appeal, or somebody's reviewing what you did, the attorney on appeal is going to have to rely on the plain error standard, which is really kind of a high bar that you're going to have to do when you could have just simply preserved the issue by objecting. Even if your objection was overruled, you've preserved the record by doing this. So this is the rule that requires you to do this. And I wanted to point out to you the standard for plain error. Now, this same language is repeated in probably 500 appellate division cases. When no objection is made, the appellate standard by which the contested evidence is judged is under the plain error rule. And here's what you're going to have to do under plain error. The issue is whether the comments had the clear capacity for producing an unjust result. Okay? Now, that language comes from Rule 210.2. An error or omission shall be disregarded by the appellate court unless it of such a nature have been clearly capable of producing an unjust result. But the appellate court may in the interest of justice. So when they talk about clearly, I guess the standard they're going to be using is clear and convincing evidence. It's something that you've got to really kind of overcome a big hurdle to show how this particular omission, failure to object and preserve this for the record, really had the clear capacity to come up with an unjust result. Everybody got that? Understand the importance of why you have to object? All right. Now, plain error not brought to the attention of the trial or appellate court. Okay, making objections during trial. Judge, I wanted you to kind of talk about each one of these. The first thing is timing of objections. Typically, you're going to have to do your objection following the completion of the question, but before the witness answers. This is so that the record will be clear as to what exactly you're objecting to, and also allow the judge a clear opportunity to make a determination as to how to rule on the objection. Do you have any thoughts on that, Judge?
That clearly it has to be before the witness answers, otherwise it becomes a motion to strike afterwards if the witness's answer is in the record. Very often the witness will start to give the answer, and I'll look at them and say, excuse me, there's an objection here, let me rule on the objection, rule on it, and then we move on.
Following the witness's answer, motion to strike, Judge, can you talk about that a little bit?
Yeah, that's it's in evidence now. We don't want it to be heard at the appellate level, so you move to strike, and then I make a ruling on that. If I agree, I move to strike it. And I forget.
How on the municipal court level do you get it out of your mind so you're not going to consider it as evidence in the case?
It just comes with training. I mean, there's a case, State versus Medina, that touches upon that. I mean, I hear this argument all the time. Well, Judge, you already heard on the motion to suppress, and you can't unring that bell. So I just assume that you recuse yourself. But State versus Medina says a professional judge should have the capability of unringing the bell and only considering what actually is legitimately in evidence.
And Joe, up at the Superior Court, what do they do in terms of cautionary instruction on something like this?
Well, the judge sometimes sua sponte will give a cautionary instruction, but you should always ask the judge to give the cautionary instruction to protect the record to make sure he does. But number two, you also want to tell the judge how to phrase it. Oftentimes judges may be a little bit too tepid, or you may want stronger language. And you may want to direct it specifically to the actual facts that were elicited by the witness that were improper, whereas a judge may simply give a general instruction. One of the general instructions they sometimes give is, where you are objecting to something which you feel is injurious to your case, and they'll tell the jury, listen, you at the end of this case will decide what is evidence and what is not and what is important. You don't want that. You want to ask the judge to tailor an instruction specifically as to the facts that were elicited, that were improper from the witness.
Thank you, Joe. Now, Joe, I want you to comment on the next one, too, just from a tactical standpoint on speaking objections. I think there's a distinction here between municipal court practice and superior court practice, because in the municipal court, the main problem with speaking objections, from my perspective, is it just wastes time. If the judge knows what the basis of the objection is, there's no point in going through a long explanation on it. Otherwise, but sometimes judges, they actually want to hear, for every objection, more detailed reasons why you're objecting. What's your thoughts on that, Judge?
I do all three. I mean, if it's obvious to me, I'll sustain the objection or rule on it before I even hear argument. Sometimes I'll look at the attorney that objected and say basis and hear what the person has to say. I'll go so far as to make my own objection. If I hear something I think is clearly objectionable, even if an attorney doesn't do it, I'll say I'm going to sustain the objection.
Okay. So I think you really have to kind of find out from the judge or get a sense of whether the judge's just his own personal predilections are to allow speaking objections or not. Sometimes judges get very, very sensitive about this. They don't want to hear speaking objections because they think it's a waste of time. Now, in the Superior Court, there's other considerations because you have a jury there. Can you talk about speaking objections, Superior Court judge?
Yes, speaking objections can be a tool that you can use in front of a jury because you can educate the jury to your point of view. I don't like it when people stand up and say objection because I don't think that jurors like, the word objection. It sounds like you're just trying to throw a monkey wrench into things, and jurors don't like technicalities. If you say objection, they think you're just raising a technicality. I think what you should rise and say is, Your Honor, that question is unfair. It's unfair because it asks for evidence which is not relevant to this prosecution. Now, the judge knows that what you're saying is objection irrelevant, but if you say it's unfair, then you're persuading the jury to your point of view because you're not attacking on a technicality. You just want simple fairness for your client. One of the problems that you have is that you should be willing to object to a speaking objection. Sometimes your adversary, the witness will not be saying what he wants him to say. You may be cross-examining a police officer, and he may have forgotten a crucial fact. And the attorney will stand up. That's unfair, Your Honor. I'm sure that this officer knows that he actually did move the bar on that machine to the left, even though he forgot to say it. And then once that's done, and you ask the officer, well, what'd you do? Well, I moved the bar on the machine to the left. And so in a speaking objection, you're instructing the witness. The counsel is improperly instructing his own witness as to what to say because that witness may have forgotten it. So A, I believe in speaking objections to the extent that you phrase them properly, they'll bring the jury onto your point of view. But number two, don't be afraid to object to your adversary's speaking objections if he's attempting to educate the witness and bring to the witness's attention things that he may have forgotten to say.
Joe, what about the sidebar objections? Where you have judges who want all objections on the sidebar?
Well, that can be tedious, and there are judges that do that. I'll tell you one thing that's important, and something that remember, you're trying this case not to a judge, you're trying it to a jury. So sometimes there'll be an objection that will be made to one of my questions, or it'll be an objection I make to my adversary's question. I'll go up to sidebar, and the judge will turn to me, very quietly and say, Mr. Rem, I'm going to hold you in contempt. There's no basis for that whatsoever. You are the worst piece of garbage that ever come in my courtroom, and I hate you. And I will nod like this the entire time. The jury will see me nodding. They think the judge is agreeing with me, and I'll do that. And I'll walk back. I'll turn to my client and go like that. And the jury think, aha, the judge is on his side. So, and you see the jury say, all right, Mr. Rem won that one. If the judge agrees with him, his client must be right. So no matter how badly he beats you up at sidebar, use that as an opportunity to persuade the jury to your point of view.
Isn't he sneaky? Right? They actually stand up, lawyers in Superior Court, when they make objections? They stand up?
Yes. It's Superior Court is a professional court.
Not an inferior court.
It's not an inferior court. Now, on arguing objections, I have this in for the younger attorney. There are no young attorneys in here. It's very sad. This is why we're going to have mandatory CLE, because typically when Joe and I and Judge McGady do one of these things, the youngest attorney's been practicing law for 20 years, okay? So we need younger attorneys to be at these things. But this is specifically here for the younger attorneys, arguing objections, okay? You make an objection, the judge will rule on it, okay? The judge may want to hear a little bit of argument on it, okay? The judge will rule on it. When the judge rules, it's over, okay? You've done your job. You've preserved the record. You've done what you have to do. You're going to be fine. Younger attorneys seem to think that they should go on and just continually argue and argue, but Your Honor, it's just so unprofessional. And it's aggravating and annoying and unnecessary. So, look, once you've made the objection, you've done your job. If the judge rules against you, move on. You have any thoughts on this, Judge?
Yeah, I do. It's absolutely right. Once I've ruled on it, I really don't want to hear another argument. But very often, the attorney will give me the basis for the objection, and I'll probe a little further. And I'll say, well, but isn't this, and this right? And I mean, shouldn't we come in for that reason? Give them an opportunity to respond to my thought process. And when they respond, then I'm going to make the ruling. I don't want to hear any more